Welcome to the League of Women Voters Forum for the Illinois Supreme Court District 2 and the Illinois Appellate District 2 judicial candidates. Forums for candidates for judicial posts are not held frequently, and there are limitations on the questions that can be asked of the candidates vying for judicial posts. Because of this, many voters are unfamiliar with the court system and the roles that judges have in our democracy. For this reason, we have invited Illinois Supreme Court Justice Ann Burke to give a brief introduction to the judicial system in Illinois. Chief Justice Ann Burke is a member of the Illinois Supreme Court representing the 1st Judicial District. She was appointed to the Supreme Court on July 6, 2006. She was elected in 2008 and was retained in November 2018. On September 2019, she was elected by her colleagues to serve as Chief Justice, and on October 26, 2019, her 3-year term as Chief Justice of the Illinois Supreme Court commenced. Prior to joining the Supreme Court, Justice Burke was appointed to the Appellate Court in 1995 and was elected the following year to the Appellate Bench, where she served until July 5, 2006. Her judicial career began earlier in 1987 with an appointment to the Illinois Court of Claims by Governor Jim Thompson. She was later reappointed by Governor Jim Edgar. Before serving on the Illinois Appellate Court, Justice Burke was appointed Special Counsel for Child Welfare Services by Governor Jim Edgar and made a member of his Legislative Committee on Juvenile Justice. She provided in-depth leadership in reshaping and improving the Illinois juvenile justice system. Prior to her judicial career, Justice Burke was a physical education teacher with the Chicago Park District, where she worked with children with learning differences. Having recognized the positive impact that sports competition had on her students, she championed the idea of a citywide competition. This ultimately led to the creation of the Chicago Special Olympics in 1968 and grew to become the International Special Olympics, reaching tens of millions in 192 nations across the globe. She later served as a director of the International Special Olympics and remains involved today with the Chicago Special Olympics. For more than 2 years, between 2002 and 2004, Justice Burke served as interim chair, directing the efforts of the National Review Board of the United States Conference of Catholic Bishops in its investigation of the causes and effects of the clerical sexual abuse scandal, and helped to establish guidelines and policies for effectively responding to the scandal. She currently serves on the Executive Steering Committee of the Illinois Kennedy Forum of She currently serves on the Executive Steering Committee of Kennedy Forum, Illinois. As a member of the Illinois Supreme Court, Justice Burke is a frequent speaker and panelist before many civic groups and local bar associations. Justice Burke is married, has 5 children and 9 grandchildren. I would like to introduce Illinois Supreme Court Justice Ann Burke.
Thank you very much for that very kind introduction. And I want to thank the League of Women Voters throughout the district for hosting this event and for inviting me to speak today. It is my pleasure to have this opportunity to provide the voters of the 2nd Judicial District some information about our judicial system in Illinois. And to put things into perspective, I thought I would begin by informing you about the history of our court system and its evolution to what it is today. So on December 3rd, 1818, Illinois became the 21st U.S. state. And in anticipation of statehood, a constitutional convention was held in Kaskaskia, our first state capital. And for our first Illinois Constitution, which was adopted on August 26, 1818. Article 4 of that first Constitution provided generally for a state judicial system, stating that the judicial power of the state shall be vested in one Supreme Court and such inferior courts as the General Assembly shall from time to time ordain and establish. And now initially, there was to be one Chief Justice and 3 Associate Justices. All justices of the Supreme Court and any judges of inferior courts were to be appointed by ballot of both branches of the General Assembly, commissioned by the governor, and were to remain in office during good behavior until 1824, at which time the General Assembly could choose to reappoint any justice, dismiss any or all, and add additional justices if the General Assembly so desired. Clearly, under the first Constitution, the judicial branch was not treated as a co-equal with the executive and legislative branches of government. Now, rather, the General Assembly was given complete authority over the judicial branch. There were no legal criteria which guided the legislator's exercise of its authority when appointing Supreme Court justices. For example, one of these first 4 justices, William Foster, had no legal training, was on the court for only 1 year, and never fulfilled any of his judicial duties, and he got paid. The General Assembly divided the state into 4 judicial circuits. However, it appointed no circuit court judges. Instead, the 4 Supreme Court justices were required to run the circuit, which meant they periodically traveled, typically by horseback, to each circuit, where they presided over trials and decided accumulated cases in the jurisdiction, all for the annual salary of $1,000. And in 1824, the General Assembly added a 5th Supreme Court justice and divided the state into 5 judicial circuits. It also created 5 circuit court judgeships, 1 judge for each of the circuits. None of the terms of office for any of these new judges was fixed. Rather, they served at the pleasure of the General Assembly and could be removed at any time upon a 2/3 vote. In fact, 3 years later, in 1827, a new General Assembly legislated out of existence the 5th justice position and the newly created organization of judicial circuits and judgeships. Thereafter, from time to time, new circuit courts were added and circuit court judges were appointed. And by 1838, there were 9 circuit courts and 9 circuit court justices across Illinois. Then in 1841, the judiciary was recognized and reorganized once again. The reason for the change was that the 2 parties at that time, the Whigs and the Democrats, were at odds with each other. And there was a very, very heated case. And the Whigs had won a 3-to-1 advantage in the high court. And Stephen A. Douglas pushed a court-packing bill through the legislature because he was very angry for losing. As a result, all circuit court judges were removed, and the Supreme Court was increased now to 9 members. And guess who was part of the new Supreme Court judges? Not surprisingly, but Stephen Douglas was appointed to one of the new positions on the court. In total, between 1818 and 1848, the Illinois General Assembly appointed 23 justices to the Illinois Supreme Court. Also during this period, numerous circuit court judges were appointed and removed. This constant change wreaked havoc with the legal system. Therefore, in 1848, when a new constitution was adopted, it established a Supreme Court composed of 3 justices who were to be elected by popular vote. 1 justice from each of the 3 newly created grand divisions of the state. centered in Mount Vernon, Springfield, and Ottawa. The first 3 elected justices, John D. Canton, Samuel H. Treat, and Lyman Trumbull, were elected to a term of 9 years and were required to convene as a court 3 times a year, once in each of the 3 divisions. Since 1848, all Supreme Court justices have been elected by popular vote in partisan elections. Now, there is an interesting sidelight regarding Lyman Trumbull. He was a Democrat, and then a Republican, then a populist. Trumbull co-wrote the 13th Amendment, which abolished slavery in the United States. And in the 1868 impeachment trial of President Andrew Johnson, he voted to acquit Johnson despite heavy pressure from the other Republican senators. 22 years after the second Illinois Constitution was adopted, Illinois adopted a third Constitution of 1870. And under this new Constitution, the state was divided into 7 districts, and the Supreme Court was comprised of 7 justices. It's the same number which we have today. 1 justice was elected from each of the 7 districts to serve for a 9-year term. Now, importantly, however, the Constitution of 1870 provided for the establishment of appellate courts for the first time. So as a result, in 1877, 4 appellate courts came into being, 1 in Cook County, 1 in the Northern Division, 1 in the Central Division, and 1 in the Southern Division. Each appellate court consisted of 3 judges who were appointed by the Supreme Court and selected from the Circuit Court. These appointees were for 3 years. Each court heard appeals twice annually. 100 years would pass before another Constitution, the Constitution of 1970, was adopted. This Constitution that we currently operate under today. The judicial article of the Illinois Constitution of 1970 is Article 6. It provides for a unified 3-tiered judiciary consisting of a circuit court, an appellate court, and a Supreme Court. It also requires the state to be divided into 5 judicial districts for the selection of Supreme and Appellate Court judges, with Cook County comprising the 1st district and the remainder of the state divided by law into 4 judicial districts of substantially equal population, each of which shall be compact and composed of contiguous counties. The Supreme Court consists now of 7 justices, elected in partisan elections to 10-year terms. Now, based on population, Cook County elects 3 Supreme Court justices, while each of the 4 judicial districts outside of Cook County elects 1 Supreme Court judge. Besides being the state's highest court, the Illinois Supreme Court has administrative authority over all state courts. Our Supreme Court rules govern the entire court system and direct its day-to-day operations. Now, unlike the appellate courts, where the final judgment of the circuit court is appealable as a matter of right, the Supreme Court has immense discretionary control over its docket. With very few exceptions, as provided by rule, the appeal of a final judgment of the circuit court rests with the appellate court. After the appellate court enters judgment, appeal to the Supreme Court is by petition. A petition for leave to appeal will be granted by the court if at least 4 members of the Supreme Court vote to hear the matter. The rule of 4, it's called. There are parameters that we typically follow when deciding to grant leave to appeal. Generally, a petition will be granted in a case that presents an issue of very first impression, that is, an issue that has not yet been considered by the Supreme Court, or if the issue is one of importance, is likely to reoccur, and its resolution necessary to provide guidance to the bench and the bar. Also, the court will typically grant appeal if there is a split among the appellate courts that needs to be resolved. As noted, I said before, the Supreme Court justices are elected to a term of 10 years. At the expiration of a judge's term, the judge may seek to be retained for an additional 10 years in a retention race. The judge is uncontested, but must receive at least 60% plus one of the vote in favor of the retention. Now, if a vacancy should occur on the Supreme Court for any reason, the court may appoint an interim justice. Now, if the person so appointed wishes to maintain their position on the court, he or she must stand in the next general election. Actually, this is the path that I followed to be a member of the Supreme Court. I was appointed to the Supreme Court on July 6th in 2006, after being nominated by Justice McMurrow, the first woman to become an Illinois Supreme Court justice and the first woman to become Chief Justice of the Illinois Supreme Court. And I was appointed to fulfill her unexpired term upon her retirement. Then I won the election to the position in 2008. And I ran for retention in 2018 and was elected for another 10 years. And in 2019, I was elected by my colleagues as the Chief Justice of the Supreme Court. The past 3 years have been very tumultuous for the judicial branch. And for me as Chief Justice, due mainly to the unprecedented global pandemic. COVID-19 created numerous logistical changes for our court system. We needed to fulfill our constitutional mandate to provide access to justice for all the people of the state of Illinois and still maintain everyone's health and safety. And despite these ordeals, I have often said that the pandemic was the challenge we didn't want, but surely it was the challenge the court system needed. In some ways, our court system had become outdated and needed to be brought into the 21st century. The pandemic necessitated this change, particularly in transforming to remote platforms, meetings, hearings, and some trials. And these changes have ultimately improved the functioning and saved quite a bit of money for the court system. These changes will also continue to have a positive impact on the delivery of justice to the people of the state of Illinois for many years to come. In addition, I can proudly say that the court enjoyed unprecedented cooperation from all the judges and court stakeholders throughout our state in the implementation of all these changes. Also, new lines of communication were created so that the pandemic, throughout the pandemic, and the Supreme Court maintained regular contact with each chief circuit judge and appellate court justices by Zoom or telephonic conference. We discussed the court's responses to the challenges brought about by the pandemic, and in this way, any concerns could be addressed very swiftly. We've had over 40 full Supreme Court meetings on Zoom, which is a record for 40 years, I think. Another major challenge during my term as Chief Justice has been the redistricting of the 4 judicial redistricts outside of Cook County. And for more than 50 years, since 1964, the boundaries of the judicial districts have remained the same. Then on June 4th, 2021, the legislature enacted and Governor Pritzker signed into law Public Act 102-0011, known commonly as the Judicial Districts Act of 2021. So when you look at the maps of the judicial districts, they were the before and after the redistricting. You can see how this historic legislation significantly changed the boundaries of the 4 judicial districts outside of Cook County, redefining these districts based on the population as it is today. Presently, the 5th Judicial District stretches from Cairo to Champaign, a distance of close to 250 miles. And the 4th Judicial District now extends from Jerseyville to Rockford, and even further distance of over 275 miles. The 3rd Judicial District was reduced from 20 counties to 7, and the 2nd Judicial District now encompasses only 5 counties instead of 13. Also, 1/3 or 8 of our 24 judicial circuits moved into new appellate districts. So while redistricting was necessary to ensure more equal representation of the citizens, redistricting also created a number of logistical challenges for us, for the court system. It required numerous changes to the processing of appeals, updates in e-filing and case management systems, software, distribution of staffing, and judicial resources. It also required all the stakeholders and members of the bar, as well as the education of people, to look into where they are now located. As a result of the Redistricting Act, some appellate judges found themselves in the position of no longer living or residing in the district where they had been elected to serve, creating a number of challenges for these judges, particularly those running for election and retention in the upcoming June primary and November elections. So I'm sure you probably are most interested in how judicial redistricting has affected the 2nd district, particularly with regard to the Supreme Court. And you probably know from December 2000 until February 2020, the 2nd district was represented by Supreme Court Justice Robert R. Thomas, who is now going to be a Lincoln Laureate this coming weekend. Upon his retirement in 2020, he nominated Michael Burke to fill his unexpired term, which meant that Justice Burke, no relation, was required to run in the next general election to retain his seat on the Supreme Court bench. However, due to redistricting, Justice Burke no longer lives within the newly drawn boundaries of the 2nd district. So Burke's county of residence is now located in the 3rd district. Justice Robert Carter, who was appointed in 2020 to fill Justice Thomas Kilbride's vacancy in the 3rd Judicial District, has chosen not to seek re-election to that position. Therefore, the 3rd district seat will be filled by an open election, and Justice Michael Burke has declared his intention to run in the open election for that position. That means that the Supreme Court Justice position representing the 2nd District is also an open race. Now, when you go to the polls, what you should be considering is the candidate's background and experience and their judicial temperament and their service to your community. Beyond that, I cannot make recommendations or suggestions. It would be a violation of ethics to do that and make a recommendation. Also, the candidates are constrained by judicial ethics from indicating how they might vote on a particular issue. Judicial ethics requires that they remain impartial and decide cases, not issues, based on the facts that are presented to them. Exercise of your constitutional right to vote, not only for Supreme Court judges, but for all elected officials. It's an important civic duty, and I wish you all the best. Thank you for inviting me.
Thank you. Good evening. It is an honor for me to be moderating tonight's Republican and Democrat candidate forums for the Illinois Supreme Court, followed by a forum for the Democratic Appellate Court candidates. Throughout its history, the League of Women Voters has been providing opportunities for candidates seeking public office to speak directly to the voters through forums. All Republican and Democratic candidates for the Illinois Supreme Court were invited to participate tonight. We will first hear from the Republican candidates, followed by the Democratic candidates. All candidates attending tonight have signed and returned the ground rules by the deadline established in the invitation. These rules specify the format, time limits, and other rules related to the conduct of the forum. I will be responsible for enforcing these rules. The candidates will begin in alphabetical order with their opening statements. They will then alternate in order in which they answer questions. After the question portion of the forum, each candidate will be giving a closing statement. Each candidate will be given 2 minutes for their opening statement, 1.5 minutes to respond to each question, and 1 minute to make a closing statement. Their responses will be timed, as you will see on the screen. The questions have been gathered in advance from the public. A panel of experienced members of the League of Women Voters have reviewed the questions submitted and carefully screened questions for appropriateness for the office and to avoid duplication for tonight's event. The format tonight is a candidate forum, not a debate format. Candidates are expected to accurately represent the facts. The League of Women Voters is not responsible for the accuracy of statements made by candidates. It is the responsibility of the public, news media, and opposing candidates to fact-check statements made by candidates if deemed necessary. The forum is held as a service to the voters so that they can hear directly from the candidates regarding views on key issues and qualifications. Candidates' responses reflect their own views and opinions and will refrain from commenting on the views of other candidates. The event tonight is being recorded. The League claims copyright ownership of any recording or transcript produced from the forum. The forum will be posted in its entirety on the host League's websites, social media platforms, and the Illinois Voter Guide. Any other use of the forum recording requires the express written approval of the League. Audio and video must be broadcast unedited and in its entirety, except by media reporting on events. Finally, I want to emphasize how grateful we are to these candidates who are not only willing to serve in office, but who have agreed to come here this evening. So first, let's hear from the Republican candidates for the Illinois Supreme Court. First, candidate Mark Curran. And candidate Curran, you want to make sure you unmute yourself, please. Next, candidate Suzanne Fayette Hutchinson. Candidate John Novarini. And candidate Daniel Shanes. And candidates, I ask that you all unmute yourselves. Welcome, thank you for joining us. And let's begin with opening statements. Candidate Curran, your opening statement. You have 2 minutes.
Thank you. I want to thank the League of Women Voters for having this forum this evening. My name is Mark Curran and I'm running for Illinois Supreme Court. For those of you that are from Lake County, Illinois, you may know the name. I was the longest serving sheriff from Lake County. And prior to that, I was a county, state, federal prosecutor. I started in the Lake County State's Attorney's Office back in 1990. Served from there from 1990 to 1998. I was in the Attorney General's office from 1998 to 2002, where I started up the Sexually Violent Person Bureau, went on to become Chief of Trials and Gangs. I was also a Special Assistant United States Attorney at that point in time. Went out into private practice and was in private practice for myself from 2002 to 2006. Handled some of the most serious cases in Lake County. And from 2006 to 2018, I was the Lake County Sheriff and also the Lake County Coroner for a period of time during that. Additionally, I went out, or subsequently, I went out into private practice again and ran for U.S. Senate in 2020. So there's a couple things that I think the voters want to know. Essentially, we have a primary process. The primary is on June 28th. You have 2 questions. One is, who best represents your values as a Republican? And if you Google Mark Curran and you go right down the list of all the issues that might be important to you, whether it's abortion and pro-life and the sanctity of life, or it's the Second Amendment, or it's liberty, right on down the line, Mark Curran has defended those values that are important to Republicans. I have done so for years and years and years and years. And so it's not a roll of the dice with regards to who Mark Curran is and what he stands for and what he would do if he is our nominee for Illinois Supreme Court. Secondly, I think for Republican voters is this is a purple map. We're looking at 5 counties and you want a candidate that's going to win. And Mark Curran was consistently the highest percentage of any Republican on the ballot in Lake County, Illinois, won by big margins.
Thank you.
All those years.
Thank you, candidate Curran. Could you please bring your remarks to a close?
Certainly. So I would submit to you that if you want to win and you want somebody that represents and reflects your values, as a Republican that will defend liberty, that will defend the Constitution. If you're concerned about the direction that Illinois and America and liberty is headed, Mark Kern is the right candidate for you. Thank you very much.
Thank you. Candidate Hutchinson, you have 2 minutes for your opening statement.
Thank you very much, both to the League and to the honored guests who are with us tonight or taking the time to be here and to listen. As we've heard, it's difficult sometimes to know who judges are and what they stand for. My name is Susan Fayette Hutchinson. I'm in my 41st year on the bench here in this area known as the 2nd District. I started in McHenry County as an associate judge and then a circuit judge. And after 13 years there, I left to become an appellate court justice. And I have been on the appellate court since 1994. I have been retained twice. I have been evaluated by bar associations, both the Illinois State Bar and local bar associations. And that evaluation includes this year. And in fact, I have been considered highly recommended in all of those elected opportunities. And I'm grateful for that as well. I've served in almost every assignment that a judge can sit in. And presently in the appellate court, we hear cases from traffic court to multi-million-dollar cases involving refinances, medical malpractice, which of course are quite sad, and termination of parental rights, which is a very, very difficult area. I've had administrative responsibility in my own court, and as chair of certain committees of the Illinois Supreme Court, that information is available. And if you want to know how I am likely to rule, while I can't tell you, I think if you go to the Illinois Supreme Court website, you are going to see hundreds and maybe even 1,000+ decisions that I have either authored or participated in. And that will give you a flavor of who I am, how I decide, and what I decide. And while I can't promise you lower taxes, I can't promise you that you'll be rich the day after the election, I can promise you that I will continue to fairly serve the people of the 2nd District, and I would appreciate your support in June. Thank you.
Thank you. Candidate Novarini, your 2-minute opening statement.
Thank you very much. Thank you for the opportunity. Thank you to the League. I'm Judge John Novarini. I'm a non-establishment, independent, grassroots conservative, and I'm running for the Illinois Supreme Court. The Supreme Court race this year is probably the most important race, not probably, is the most important race on the ballot. It's more important than the governor's race. It's more important than the U.S. Senate race, because this race will determine who controls the Supreme Court for at least the next 10 years. The Illinois Supreme Court has been controlled by the Democratic Party since 1964. Think about that. That's 58 years. The Democrats have controlled the Illinois Supreme Court. It goes back as far as LBJ, Otto Kerner, and Mayor Richard J. Daley. For those of you who do not know me, I've been in the legal profession for going on 35 years. I've been a circuit court trial judge for the past 14 years. During my tenure as a circuit court trial judge, I've served as a presiding judge of the Family Law Division, presiding judge of the Criminal Law Division, where during my tenure, I've presided over close to 100 criminal jury trials. I've also presided over the probate court, the guardianship court, the traffic court, and the mental health courts. I've experienced in family, civil, and criminal courtrooms. I've enjoyed the past 14 years on the bench, and I've considered it an honor and a privilege to wear the robe and serve the people of Illinois. Prior to going on the bench, I spent 25 years in the private sector. I've experienced in business, banking, and education. I've taught at Judson University for the past 14 years. I've taught law, ethics, business, and government. Educationally, I'm a graduate of the Moody Bible Institute in Chicago. I also hold a master's degree in history from Northeastern Illinois University. And my law degree is from IIT Chicago-Kent College of Law. I've served my community in a number of elected positions. I served as a village trustee in Carpentersville. I was elected twice to the Kane County Board, and I was elected to the bench in 2008, retained in 2014, and then retained again in 2020. So public service has been important to me. I've also served 17 years on the Salvation Army Advisory Board.
Novarini, I'm going to ask you please to bring your comments to a close.
Thank you, I will. So I ask for your vote and support on the June 28th primary. Thank you.
Thank you. Candidate James, 2 minutes opening statement.
Barb, thank you. And thank you to the League for putting all this together, bringing us together to talk about this very important election. I'm Judge Daniel Shanes. I am in my 16th year of serving you on the bench. I'm currently the Deputy Chief Judge in Lake County. I was initially appointed, then elected, then retained. So I've been through all three of the ways, I suppose, people become judges in Illinois. Chief Justice Burke talked about that. I've served and presided over just about every kind of case that exists in a court system. And I currently preside over the most serious felony cases as well as the most serious civil law division cases. Judge Hutchinson described several of those. When you think about somebody who is qualified and who you want to sit on the Illinois Supreme Court, I suggest to you that there are a couple of very important criteria, and Chief Justice Burke touched upon this as well. You want an experienced judge who can decide the issues and approach the position with the experience and humility of knowing what it means to serve as a judge. You also want a judge who can not only be a good judge, who will follow the Constitution and the rule of law, but you want a judge who also has experience in judicial leadership. Because as the head of a co-equal branch of government, the Illinois Supreme Court not only decides cases and how the law is applied, but as Chief Justice Burke said, also has the supervisory and administrative authority over the entire judicial branch. My experience in serving on the COVID task force that actually Justice Burke mentioned was a true honor in getting us through the last couple of years of the pandemic. My experience in teaching judges, not only in Illinois, but also around the United States as a member of the faculty of the National Judicial College has provided these opportunities as well. These are the types of things that we need to look at for who will be elected to the Illinois Supreme Court. For more information, Barb, just to keep things moving and on track for your timing, for more information about my background, please go to the website, judgeshanes.com, Google it, you'll find it. Thank you for being here tonight.
Thank you so much. The first question will be directed towards you to start us off, Candidate Hutchinson. The question is, what are your thoughts on how to reduce the lengthy delays in court proceedings that often stretch cases into costly multi-year affairs?
Well, I can say in the appellate court, that is not the problem. We are very timely in the second district, and we work hard at staying that way. As far as trial courts go, a lot of what happens in a trial court relates to the area of jurisdiction. We've heard of cases in Cook County that have been on the docket for years, and the defendants have never made the courtrooms. We've heard of pleas that happen almost overnight when someone comes into the courtroom and has an attorney who takes care of their case. I think the important thing is that all people should have their opportunity to get their case heard in a timely basis. There are Supreme Court rules and statutory authority for that purpose, but a lot of it requires judges to be strict with the rules, to impose timely restrictions, and to understand that these people need to have a disposition today, not whenever it's convenient. Lawyers bear a significant burden in this regard, and they likewise need to be professional and make sure that their clients have been advised of their rights. I don't know how many cases we have seen where litigants say, I never talked to my lawyer. He saw me once before I went to court, or she saw me twice before I went to court. That delays proceedings. And so I would say additional training for judges, which I'm happy to do, as Judge Shanes has done, and likewise continuing education for lawyers. Thank you.
Thank you. Candidate Novarini, your response.
Thank you. First, I'd like to say I pride myself in moving cases. When I was a lawyer, that was always a frustration, how long things would take. But there are certain things that judges can't control and can't control. For instance, if you got a defendant, sometimes it's in their best interest to prolong the case. Witnesses move, witnesses die. So they want the case to go on as long as possible, or if they're sitting in Kane County Jail and they know they're going to be convicted because they're guilty, they'd rather sit in a Kane County jail, a jail instead of a prison. But the thing is, judges do have a certain amount of control. And again, I move cases. The big thing is judges need to make decisions. And that's one of the marks of a good judge. You know, one is you have to be a good listener. Two, you have to have an excellent demeanor. Three, you have to be able to make a decision, all right, and move a case. Hopefully, judges will get more right than they get wrong, but you can't sit there and ponder a case. It's not fair, especially in 4 years I sat in the family law division, child custody cases. Those are the cases that you really have to make sure that the attorneys are moving their case forward, because you're dealing with kids' lives, and kids need to be settled, and cases need to be settled. So in cases where you're dealing with children, it's very important that these cases are expedited and settled and moved on. Thank you.
Thank you. Candidate Shanes.
Thank you. Justice delayed is justice denied. There's no question about it. And at the risk of echoing a little bit of what Judge Noverini and Judge Hutchinson said, these are issues that are vital to every trial judge. What we need are two things. To answer your question, we need a Supreme Court that will lay out clear lines as to our standards. And actually, our Illinois Supreme Court is now in the process of doing that. And I'm proud to be part of that through the Judicial Conference. I'm one of 15 judges that the Supreme Court picked to be part of the Illinois Judicial Conference to work on strategic planning. So we are doing that. And the Supreme Court, as part of that, needs to make clear that the rules are that. They're rules. They're not suggestions. They're not aspirational. And the other thing that we need are trial judges and a bench and a bar who will abide by them. When it comes to child custody cases, when it comes to guardianship cases, when it comes to criminal cases with victims of crime and defendants accused of committing crime, we need to know that cases will move forward, and we need judges who will enforce those rules. That is a vital part of docket management. One of the things that various associations like bar associations and the Illinois State Bar Association, Judge Hutchinson mentioned it before, judges and lawyers evaluate us judges on things like docket management and temperament and legal ability. And I'm pleased that the lawyers and judges who come before me have rated me highly qualified, and you can look at what they say about my skills in docket management.
Thank you.
Thank you.
Candidate Curran.
Thank you. I think that what we need in terms of solving this issue as to how long it takes to get to trial and how long cases take is someone that has the background in terms of all facets of the criminal justice system. We have somebody, that comes from Lake County, Illinois. And I would submit to you, Lake County, Illinois is renowned for wrongful convictions above essentially almost any other county in America. The New York Times spent 11 pages in a Sunday magazine talking about what's wrong with Lake County, Illinois. So if your only job historically has been to be a prosecutor in Lake County, Illinois, under Mike Waller, who was essentially the poster child for wrongful convictions, then you're looking at it from a prism that's just not fair and just not healthy. So I agree, justice delayed is justice denied. The problem when we talk about civil cases, a lot of times that a plaintiff's lawyer is limited in terms of the money they have, and then you have a big defense firm that can just bury them in terms of discovery and everything else and drag it out in the hope that they'll settle for substantially less. And in terms of a criminal case, well, we deal with, statutes in terms of how long somebody can sit in custody while waiting for trial. Those were modified with regards to the COVID, but by the same token, there is some benefit sometimes to delaying a trial if you're on the defense side. But ultimately, all of this goes to the bigger question of what's justice. And Lake County, Illinois, from when I had offers.
I'm going to ask you once again to bring your comments to a close.
Certainly.
Timer has indicated time's up.
Certainly, but I think the League of Women Voters that it has had the heart for minorities and others that have been wrongly convicted over the years, and they look at Lake County and what happened there. That's not the model, and we need to do better.
Thank you. Candidate Noverini, this question will start with you. What changes in the law, such as the Criminal Justice Reform Bill passed last year, do you expect to have the greatest impact on court proceedings and decisions?
Probably what will affect mainly, I would think, Cook County, and not so much the Collar County, is the no cash bail, which would begin January 1st. That I think could end up being a problem. Everybody thinks it's a great idea until somebody gets killed. I mean, initially, what we do as judges, a defendant comes in, we hear it from the state, you know, we get the history, we hear what they're accused of, then we hear it from the defense as far as mitigating circumstances, and then we make a decision and we set a bail. We base it on, you know, basically the safety of the community and the flight risk, whether the person's a flight risk. They've pretty much taken that out of the hands of the judge. I mean, that's what we get paid for, is to make decisions. Beginning January 1st, 2023, Illinois will be the first state to go with no cash bail. I think this is going to be something we're going to have to navigate it. The legislature came up with this, and now we got to figure out how to work with it. But I think that could have a big impact. Again, as I mentioned, mainly in Cook County. I think the Collar counties won't feel quite the same impact as Cook County.
Thank you. Candidate Shanes?
Sure, Barb, your question was about what legislative reforms are going, we think, might have the biggest impact on judicial proceedings and the court system. I'm going to rush to note that your question wasn't the wisdom of those legislative reforms. Under our Constitution, in the judiciary, it's not our job to say what the best law is or the way what the legislature ought to do. Judges should not be legislating from the bench. Judges should be applying the Constitution and following the law. So as a judge, it's not my position to say, I like this law or I don't like this law. It's my job to say whether I think the law is constitutional or not. And if it is, apply it. So understanding your question that way, I'll give you two examples of recent legislative enactments that are going to affect justice in Illinois and the judiciary. One is part of the criminal justice reform. It changed everything on how pretrial supervision is occurring in Illinois. And the Illinois Supreme Court is, in implementing that law, leading in establishing pretrial supervision. I'm talking about having kind of probation officers for people who are out on bond, not in jail, in criminal cases. And that is a watershed change in how the judiciary is going to function. The other, briefly, in the civil arena, is prejudgment interest on cases. When parties don't settle their cases, and if they end up losing and they have to pay, depending upon which side you're on, high or low interest, based upon what a jury or a judge might decide, that will have an impact on civil cases as to whether they go to trial or not. Excellent question. Thank you.
Thank you. Candidate Curran, your response for 90 seconds, a minute and a half.
Thank you. I agree with Judge Noverini that I think that that's going to be a problem with regards to a lot of people not posting cash bond. And we've seen that in the evidence of that with Kim Fox in Cook County, where people have been released on recognizance bonds and immediately go out and commit a murder or another heinous crime when they should be locked up. And I think that's very problematic. You know, it's all a balance with regards to what we need. The United States has 5% of the world's population, 25% of the world's incarcerated population. So have we incarcerated too many people? Have we had policies that were racist in effect? Absolutely, no question about it. But, you know, it all comes down to a balance. And we look at what's going on in Chicago. It is a violent city. It is as violent as any place in the world. And much of that is the criminal justice policies that are not based in reality and not based in what we need to do. So let me just say one thing to what Judge Shane said just before. Don't let people do that to you. That is an absolute bold-faced untruth. So there's a case, the Republican Party of Minnesota versus White, that says that candidates for judge, appellate court, or Supreme Court are allowed to state their personal opinions. And that is an absolute fact. And so when somebody says that, they're trying to dodge you and trying to hoodwink you, and you don't know who they are, and that's just not fair.
Candidate Curran, thank you.
Barb, since the rules, if I may, since the rules,
I know that I'm going to address that. Okay.
Thank you.
Because we are going to ask that we not attack or challenge other members of your forum, and to act with respect and civil discourse.
I just appreciate the chance to respond later.
Thank you. Candidate Hutchinson, your response. Do you need me to repeat the question?
No, I think I remember. Thank you.
Okay, thank you.
Having just attended the Illinois Judicial Conference that's held every 2 years and listened carefully to several lectures about the Safety Act, which is what several of us have alluded here to today, it is clear that we will have additional responsibilities as judges. Probation officers will have to probably be on duty for 24 to 48 hours straight, and will have to alternate because reports are due to the state's attorney's office. The state's attorney's office will have additional responsibilities. Everyone within the court system will have additional responsibilities. And how that will pan out, we're still not sure, because they're inconsistent, at least appear to be inconsistent time limits. In the civil side, parental rights and taking care of children, there's legislation almost every time you turn around. Setting time limits for when cases can be decided. And sometimes those time limits are just difficult to comply with because parents disappear, parents are in custody, parents cannot respond, parents can't attend what they have to do, and the children remain in limbo. So as I said earlier, I think it's critical that we follow those time limits, and we have to find better ways to do so. We need help from DCFS. We need help from all of their subsidiary agencies to make sure we have adequate reports. And although this is not new legislation, particularly, it is significant over the time that I have been on the court or in the system. Thank you.
Thank you. Candidate Shanes, you'll start the next round of questioning. And the question is this: what are the effects of undisclosed and outside contributions on judicial elections? And what impact will the new judicial campaign finance rules, HB 716, have?
Sure. So let me address that in the context too of the comments from before. It's important to distinguish between a judge's role under the Constitution and a judge's ability to speak under the First Amendment. We all have First Amendment rights. Judges, those of us who have chosen to become judges, choose not to exercise our First Amendment rights so that we can perform our judicial function. Part of the question that you just asked is, well, what is going to be the effect of this? And I didn't write it down, so I don't remember exactly what you said. How is it going to affect things when we talk about campaign contributions and whatnot? The United States Supreme Court has addressed this in a First Amendment context, that campaign contributions are a form of political speech, and yet the U.S. Supreme Court has held it can be regulated in some way. There are some new campaign laws and I think you referred to one, that have come through the legislature in the last 12 months. These laws all get litigated, and as a judge, I do hope to be on the Illinois Supreme Court, and that is where I'd like to render an opinion on exactly whether that law is constitutional and not. If, for a judge who would express an opinion, or a judicial candidate who would express an opinion on the merits of a law outside of court, they become disqualified from hearing that case. And I'm not running to sit on the sidelines. I'm running to uphold the rule of law on the Illinois Supreme Court. How will it play out in the political arena? We'll find out. I don't know. That's beyond what a judge can establish. But insofar as the merits of the law and the role of a judge under the Constitution, that's what we're talking about. Thank you.
Thank you. Let me repeat the question, Candidate Curran. What are the effects of undisclosed and outside contributions on judicial elections? And what impact will the new judicial campaign finance rules, HB 716, have? And you have 90 seconds.
Thank you. I think that money's a big problem, especially in judicial races. And you look at Lake County, Illinois, and I'll just take that for an example, because that's where I spent much of my career. There was one candidate that got out in front in terms of money, very much so. And You know, a lot of it was Masonic money. And, you know, ultimately these people were able to write big, big dollars. And I think that's a problem. I think the changes in the law with regards to not taking money from out of state, I think that's a good one. I think anything that we can do in terms of limiting, you know, corrupt money, dirty money to judicial candidates is all good. I think that, you know, with this First Amendment balance, I agree with that, but by the same token, that's soft money, you know, that comes in, you know, Ken Griffin, you know, who's he with, right on down the line. What do they want in exchange? People don't write checks for no reason at all. There's a quid pro quo. I think most of your listeners out there know that that's the reality. So I think that we do need to be very, very careful with regards to money and where it comes from. And I hope nobody thinks that every time you have an opinion on something and you voice that opinion, that you're disqualified from ever hearing a case on that subject. It is an absolute absurdity, and there's nothing that supports that. So I welcome a lot of these changes in terms of soft money. And I think that when you look at where the money is, especially in judicial races, these people, they didn't write these checks for nothing. They want their guy. And when they got their guy, you know, they're happy and they expect something in return. Thank you.
Candidate Hutchinson.
Thank you. Money for judges or on two judges is not new in any event. I remember a time when the National Judicial College, which sits on the University of Nevada at Reno, was financed almost exclusively by liquor companies, Jim Beam in particular. And one day when a journalist asked the then executive director, the CEO of Jim Beam, about why was he supporting the college, or why would they putting big money into the college? He said, it's never a bad idea to have a judge who owes you something. So it's come up again in dark money, in other types of money that's being collected. I think dark money might go a bit far. I have relatives out of the state who cannot contribute to me through any means. They're probably happy about that, but that's not the point. I'm not happy about that. And so I think it's important that we know where the money's coming from. We know what the money may mean, but I don't believe, even in my experience on the appellate court all these years, that money should decide any case. Your responsibility as a judge, your ability to follow the law is what decides the cases. Is that difficult when a lot of money is involved? It shouldn't be, because that's what our oath says, that we will support the Constitution of the United States and the laws of the state of Illinois. It doesn't have a parentheses, notwithstanding where we got the money to be in that position. Thank you.
Thank you. Candidate Noverini.
Thank you. Yeah, I agree with pretty much what everybody else has said. I too have friends and relatives that sent me money. I had to send it back because we couldn't accept contributions from out of state. But I think what we need is a level playing field. The legislation prohibits any out of state money from coming in except if it's from a union. And where do you think union money goes? So I don't think we've got a level playing field. I think this legislation is going to have to be looked at. In addition to speaking of a level playing field, gerrymandering of the districts. Second district has been gerrymandered. Second district forever, since the beginning of the second judicial district, has been Republican. Now it consists of Lake, McHenry, Kane, Kendall, DeKalb counties. Everything west of McHenry County all the way out to Iowa has been taken out. And it's been taken out for a reason, because those are all Republican precincts and counties. So what I think is important, not only when it comes to money, but when it comes to jurisdiction and gerrymandering of districts, you got to have a level playing field. Right now this district is probably plus 8 to 10 points Democrat, and that's not by accident. The Democrats want to control the Supreme Court, as they've controlled the Supreme Court since 1964. So I think we not only have to look at money, but we also have to look at how these districts are drawn. Thank you.
Thank you. Candidate Curran, we'll begin with you for this round of questioning. And this is the question. The state Supreme Court has given circuit judges the latitude to experiment with allowing news operations to select pool photographers to unobtrusively photograph court proceedings. In your opinion, how will this allowance affect the judicial process?
I believe in the concept of an open courtroom, and I'm a proponent of that. I think that we should have cameras in the courtroom. Forever, we've been watching trials all across the United States, but not in Illinois because we haven't allowed cameras in the courtroom. I think the cameras in the courtroom are integral to building confidence in the judicial process, and I'm a strong believer in it. Strong believer in the First Amendment. Strong believer in an open process. Like I said, once again, I came from Lake County, Illinois, and it's not like that anymore because it's a much better judiciary. But you go back, 20, 30 years, two things had to happen. You had to be a Freemason and you had to be a Republican to be a judge, and everything was secretive and everything was in the dark. And the process was not good. And we had judges that were very unfair, especially to minorities. And it built cynicism in the process. It was an ugly, ugly system. And as a young attorney, I was questioning whether I should have taken a job in the Cook County State's Attorney's Office, where I also had an offer, because as the people from Northwestern said, they've never seen anything like the Northwestern Innocence Project. They've never seen anything like Lake County, Illinois, in the way that it was run, this big county where it just seemed to railroad people and nobody ever said anything. And it was very ugly. So I think cameras in the courtroom are a good thing by and large. I think that they open the process. Let's shine the light. Let's let everybody see what's going on. We'll see whether a judge treats, people, minorities and others with dignity and respect that they deserve. Thank you.
Thank you. Candidate Hutchinson.
Cameras in the courtroom, I think, are important for transparency. There is a problem that they do present a temptation for people to act certain things differently than they would. When we do oral arguments down at Northern Illinois for the students, we have an audience and we have cameras in the facility that we're working in. And my only occasion where a lawyer misrepresented the facts of a record because they just weren't good enough for what he wanted them to be happened under the observation of a camera. And so he took that opportunity and he lost his case. That's not what we should be doing with cameras in the courtroom. We have an opportunity to use them right. We have an Illinois Judicial College that can teach our judges how to respond to them. And I think it's important that that is one of, and I know it is, the criteria that is currently being considered by the college, to make sure that we don't overreact as judges. We don't say certain things that we shouldn't say. And having read records for the last 24 years of people speaking in a courtroom, grammar and tense of verbs just really doesn't exist on a regular basis. So I think it will also be helpful with the cameras that we'll all be a bit more careful in how we phrase our holdings, in how we address the parties before us, and hopefully how the parties address us in return. Thank you.
Candidate Noverini.
Well, we do have cameras in the courtroom in Illinois. It's really at the judge's discretion. And then usually get them into high profile cases because, probably 90% of what we do is people aren't going to be, they'd be bored to watch. So it's really in high profile cases. Certainly we wouldn't use them in where children are involved or in mental health cases. But they are appropriate in some cases and they're inappropriate in other cases. And that's really why the judges make that call.
Thank you. Candidate Shanes.
Sure, thank you. Yeah, of all the judges who are here running for the Supreme Court or Appellate Court, I think that I'm the only judge who's actually used the extended media coverage, which is what the Supreme Court calls it, where we have television or whatnot for a trial. And as Judge Noverini said, it is the high profile cases where we get those requests. Transparency is good, public access is good, but like most things, everything's not all good or all bad. It depends upon the situation. And I'll give you an example. As a judge myself, who has presided over proceedings, trials, and hearings where I have granted extended media coverage, it is not appropriate in all cases, just as he said. A The trials I have granted on have been murder trials, but that doesn't mean that necessarily everything that the jury sees needs to be on television. Think, for example, autopsy photographs. If there is a sexual assault trial, the public has a right to come watch, and the Supreme Court rules provide that the judge could allow cameras. But would it be appropriate in a sexual assault trial to have the victim put out on the internet for all to see? That's a balancing thing that a judge has to decide. Gang trials, over which I preside over more than I can count. Do we necessarily want people who are testifying in a gang case to have their picture put out real time so that unsavory things might happen to them when they leave the courthouse or that night or at their homes? So all these issues have to be considered. The rules provide for it, but it is something that the Supreme Court has led Illinois in doing.
Thank you. Candidate Hutchinson, we'll begin this question with you. What is your judicial philosophy on balancing the scales of justice, weighing fairness, empathy, and the strict interpretation of the law?
Well, as I said in my opening remarks, I can't promise certain things, but I can promise for the people who rely on me that I will be fair. Balancing is a tough one because some people cannot afford an attorney, and then they get what they call this public defender, and then they say, well, I really want a real attorney. A public defender is a real attorney. And I think we have to make that clear to the people who need their assistance. There's some people who want to represent themselves, and within limits, they have the absolute right to do so. We get pro se, self-represented litigants sending us briefs from the prison institutions all the time. It is very difficult under those circumstances to balance the issues and to be fair, because most of the time the briefs are almost unrecognizable, as they have very little legal precedent, and we can't represent the parties, but we can tell them where they have gone wrong. We can tell them how they can do better if they have another opportunity. And we can even tell them what that opportunity is, as long as we don't tell them how to plead their case. So balancing is difficult no matter what area you sit in. I don't think it's any less difficult when you're on the appellate court. And I think my basic philosophy is you have to listen to everyone, no matter how difficult it may be. Everybody's case, from traffic to murder to $1 million case, is important, even though it does not appear to be.
Thank you. Candidate Noverini. Oh, Candidate Noverini, you're muted. We need you to unmute your microphone.
Yes, would you repeat the question, please?
Sure. What is your judicial philosophy on balancing the scales of justice, weighing fairness, empathy, and the strict interpretation of the law?
Okay. It's important for a judge to be not a good listener, but an active listener. All right, listen to both sides. Secondly, a judge has to be willing to learn. Okay? I went into the family law. My background was business, banking, education. When I first got on the bench, I went into the family law division. I'd never done a divorce. I never was a divorce lawyer. I've never been divorced, fortunately. But I was willing to learn, and that's what judges have to do. They have to be willing to learn because they don't know everything. Thirdly, it's demeanor. And then fourth, make decisions. And the bottom line is you have to keep an open mind. That's important. You perform your judicial duties impartially. Your personal views play no role in your judicial decision-making process. So you treat everybody that comes in with respect, with dignity, and you hear both sides of the case, and you make a decision. And again, that's the other thing. A good judge makes a decision. You can't be putting everything off to the side or putting, taking it under advisement. I've seen some judges that have stacks of files on their desk because they're taking it under advisement. People want a decision. Lawyers want a decision. So again, that goes back to moving cases. But again, keeping open mind and being impartial is what I would answer. That's how I would answer that question.
Thank you. Candidate Shanes?
Thank you. You talk about judicial philosophy. Fairness, empathy, and applying the law are not mutually inconsistent. A good judge will do all of those things. A judge's role is to apply the law to the facts of a given case. The legislature makes a law. They have some fact situation in mind when they do it. Invariably, some other something happens, and a case is about whether this law or that law should apply to a case. So a judge figures out the facts and then faithfully applies the law. In doing so, a judge can show empathy to the parties. There's absolutely nothing wrong with, and in fact, I think something good with, showing the human side of what happens. The court system, the judiciary, the people who come in front of us is a quintessentially human endeavor. We see people coming to court in usually the worst parts of their lives. Families coming apart, someone did something wrong to them, they're accused of doing something wrong to somebody else, whatever it is. These are real, raw human situations. Any judge who has ever had the responsibility and duty of sending someone to the Department of Corrections to prison for a significant period of time knows how difficult and personal that decision is. And while the judge has to follow the law and apply the law, there's nothing wrong with the judge speaking in human terms with respect to all parties who are involved, respecting the victims, respecting the defendants, respecting the mom and dad getting divorced, whatever it is, and then applying the law fairly. And that is my judicial philosophy.
Thank you. Candidate Curran?
Thank you. I think there's something wrong with the prism of only having been a prosecutor. And I want to go back 30 years, ago when I was a young attorney in Lake County, Illinois, when every judge was a Republican Freemason until they finally started putting women on the bench. I remember the judge I was in front of in misdemeanor court, and he used to say, have him fill out an application for a public defender. And he'd say, come back with 12 job, applications, and then I'll think about it. And when the deputy would whisper in his ear that this guy was HIV positive, he'd make a comment along the lines of, you don't have long to live, so you might want to start, trying to take care of this case as quickly as possible. I saw horrible, atrocious behavior from the bench. And, that's part of the problem when we live in this little bubble where echo chamber, where everybody was a prosecutor, and, we only see things from this very limited perspective. And that's why when I went down to the Innocence Project in Northwestern, they said Lake County just defies all logic to be that big and to be that corrupt. But, when I was sheriff, I spent a week in my own jail, first sheriff ever, I believe, in the history of America. And the reason why I did that was, we don't give second chances in this country. And, we can't just stigmatize somebody as an ex-con and ex-felon. We need to give them the hope and redemption and to believe that they can do things and not to have that record follow them forever. And, my background in terms of the varied interests, I think that's what will serve well on the Supreme Court. Thank you.
Thank you. Ladies and gentlemen, that was our last question. So now we'll begin your 1-minute closing statements. And we'll begin with candidate Novarini. You have 1 minute.
Thank you. Ladies and gentlemen, we have in this election an opportunity to take back the Illinois Supreme Court. We have an opportunity to elect judges who will follow the law and make sound legal decisions and not political decisions. This is why the question you really need to ask judicial candidates is, what is your judicial philosophy? How do you view the Constitution? I will follow the law. I will do my best to safeguard our liberties, and I will stand up for our God-given inalienable rights. I am an originalist. I do not believe that our Constitution is a living and breathing document that changes with our culture. If that were the case, our Constitution would be meaningless. Every morning, before I walk in the court, I pray for wisdom, and I pray for godly wisdom. I remind myself that it is my job, our job as judges, everyone, our job, our legacy is to preserve, protect, and defend our Constitution. I want to thank you for the opportunity, and I ask for your support and your vote on June 28th. Thank you.
Thank you. Candidate Shanes, you have 1 minute closing statement.
Thank you. Friends, this isn't just an opportunity. This is our responsibility as voters. This is an election where history will judge us because we have the responsibility of selecting a judge to sit on the Illinois Supreme Court, arguably for the next generation. I'm proud of the proven track record that I have for over 30 years as a lawyer and as a judge. I'm proud to stand on my record, not run from it. I'm proud that my record shows an adherence and fidelity to the Constitution and to the rule of law, to what I hope is excellence in legal ability and temperament and fairness. But don't take my word for it. Listen to the judges and lawyers and colleagues who have rated us and spoken to our ability in these areas. Look beyond what we say to what others say. I'm also proud of the judicial leadership that I have developed and exercised over the last, well, I suppose I've been on the bench. I'm in my 16th year, almost all of that. From teaching judges in Illinois to teaching judges from around the country to working to develop a strategic plan for Illinois. This is our responsibility. Please cast an informed vote in June and in November. Thank you.
Thank you. Candidate Curran, your closing statement, 60 seconds.
Thank you. I also want to thank the League of Women Voters. What a great opportunity. And I wish more would give us this opportunity so that people can see who they're voting for, especially with such an important office. So Mark Curran, who is he? You've heard, you know, as a county, state, federal prosecutor, I've probably tried more juries than anybody on the panel, great candidates and great people, but I do have that background. And so ultimately for Republicans that are going to vote initially, it's, you know, who's going to win. And I ran in these 5 counties that we're running in at this point in time in a primary 2 years ago, and I won all 5 counties, and I won them with all of them with over 50% and with ridiculously large margins. And then I went on and beat Senator Durbin in McHenry County and fought hard in the other counties and did better than President Trump did. So if you want a candidate, you're a Republican out there and you're listening and you're thinking, who do we want? I think Mark Curran is a good reason. Also, natural law. Charles Rice from Notre Dame was a mentor to me. That's what I'm going to bring to the Supreme Court, not this, you know, nonsense that we're living in, but a natural law philosophy. Thank you.
Thank you. And Candidate Hutchinson, your closing statement.
Thank you so much. And again, thank you to the League and to all of the wonderful people who are in the audience. I have worked in this area, public law, since I graduated from law school. This has been my life, and I've enjoyed that life. And since 1981 until the current time, I have worked. Sometimes it's been a labor, sometimes it's been a wonderful experience. Other times it's been an interesting experience. But I know this area, I know the people in this area, I know the problems that are facing them from both my trial court work and in particular my appellate court work. I am the only candidate who has appellate court experience. The learning curve will be minimal, I believe, for me, because everything is written. If you really want to know who I am, all you have to do is look on the Illinois State website. Everything I've said or agreed to in the last several years is in writing. And so I only ask that you consider the experience, that you consider my interest, and that you consider my sincerity when you vote on June 28th. Thank you.
Thank you. I wanted to thank all of you for joining us this evening. On behalf of those watching and myself, I applaud you for taking the time out to be with us. And you can now turn off your cameras. Thank you.
Thank you.
Thank you.
Now we will hear from the Democratic candidates for Illinois Supreme Court. Candidates will turn on your video when I mention your name. So welcome to candidate Renee Cruz. Welcome to candidate Elizabeth Rutchford. And candidate Rutchford, you can turn on your camera and unmute yourself. Candidate Cruz, you may want to unmute yourself.
Zoom is not letting us turn on our video.
Oh, no. Hopefully we have someone who's knowledgeable and can correct that in 1 second. So we have candidate Cruz, candidate Rochford, and candidate Nancy Rottering. You're joining us. Thank you. We just need candidate Cruz to come back. Maybe he signed off and came back in. So we'll wait just a moment. While we're waiting, I'll just go over and mention a few of the things that I mentioned earlier. Oh, welcome back, candidate Cruz. You can unmute yourself and turn on your video. There we are. We're all here. Okay. As I mentioned earlier this evening, all candidates attending tonight have signed and returned the ground rules by the deadline established in the invitation. These rules specify the format, time limits, and other rules related to the conduct of the forum. And I'll be responsible for enforcing those rules. So let's begin with opening statements. Candidate Cruz, you have a 2-minute opening statement.
Yes, thank you very much. And I'm just going to follow up on Chief Justice Burke's comments earlier. She mentioned to you that this is the highest court in the state of Illinois, and the job is to decide issues of constitutionality and differences within the appellate court. She also said that there's a great administrative authority of the Supreme Court that also controls the day-to-day operations of the districts. She suggested towards the end that you should consider candidates' backgrounds, experiences, and commitment to your community. And that's why I believe I'm the best candidate for this particular job. I grew up in the military. That military life allowed me to live in 3 of the 5 counties, having spent my childhood at Fort Sheridan up in Lake County. I went to law school in DeKalb at the Northern Illinois College of Law, which is the only law school in this district. And my family and I settled in Aurora, where I practiced law for 17 years as a trial attorney. I was a litigator in court every day, representing clients on every issue of the law for approximately 17 years. I grew my practice from just myself, my partner, and 1 full-time receptionist and a part-time secretary to over 20 employees before I became a judge, an associate judge in 2012. Within 4 years, the Illinois Supreme Court unanimously elevated me to a circuit court judge position. And 2 years later, I was then elected by the citizens of Kane County as a circuit court judge for my own 6-year term. Throughout that, I'm in my 10th year as a judge. Throughout that time frame, I've been recognized by my peers that I've been asked to teach at our judicial education conference. I've been asked to mentor new judges throughout the state through the cohort education process. And I've also been on panels nationally to talk about remote court systems. I'm here to tell you that I do have the experience, and through all these times, I have been a vital member of my community, giving back, having received accolades from my community for being a champion against hunger and for my community service as well. So when Justice Burke says, look at your candidate's background, experience, and commitment to your community, please visit judgecruzforjustice.com. You'll see all of that experience there. Thank you.
Thank you. Candidate Rochford, your opening statement. You have 2 minutes.
Good evening. I'm Judge Liz Rochford, delighted to be here with you this evening. I come from a long line of public servants. My parents and my grandparents alike established a model of service above self, and it is what I have aspired to every day of my adult and professional life. I was first a teacher, and I've been 35 years in and around the practice of law, clerk to a personal injury titan, worked as an assistant state's attorney. I was in private practice for more than 20 years. During that same term, I was a commissioner of the Court of Claims. And I've been 10 years on the bench, serving in the criminal division, the family division, and currently the probate division. I've been firsthand witness to litigants struggling to navigate a complicated legal justice system with everything they care about most at risk: their freedom, their children, their homes, their money. When the Supreme Court issued its mandate on access to justice, that there should be access to justice for all people, especially the poor and the vulnerable, it resonated with me. And I took the lead in developing programs and courtrooms to fulfill the Supreme Court's vision. And now I'm working with the Supreme Court on committees to bring all we've learned to jurisdictions across the state. Got a passion for access to justice, but that's not enough to qualify me for the Supreme Court. The work of the Supreme Court is vast, hearing the most important cases, educating judges, administering the courts, setting and realizing policy. It requires leadership, among judges and among attorneys. It requires experience in the courtroom, and it requires service, connecting the courts to the people that we serve. These are essential. These are precisely the things that the Illinois State Bar Association considered when they determined that I'm highly recommended to serve as an Illinois Supreme Court Justice. The resume must match the position, and mine does. I thank you for your time tonight, and I look forward to your questions.
Thank you. Candidate Rotering, your opening statement.
Thank you. To the League of Women Voters, I'm a proud member of the Highland Park Highwood League. Because of the work that I've done for decades, I was asked to run by Illinois leaders within the legal community and beyond. They reached out because they felt I had the experience and the professional qualifications to serve our state well. I've been an attorney for over 30 years. My undergraduate degree in economics is from Stanford University. I have an MBA from Northwestern, and I went to the University of Chicago for law school. In my practice at McDermott, Will & Emery, I focused on healthcare law with a specialty investigating fraud and abuse. My legal work pivoted to counseling and advocacy on behalf of students with disabilities in 2000, when my own child with type 1 diabetes entered public school. I've served the public since 2005, and in 2009, I was elected to Highland Park City Council. Immediately, my legal experience fighting fraud and abuse raised ongoing concerns about the ethics of the city's leadership, and 2 years later, I ran for mayor. I'm now in my third term. As a city, we focus on what matters, with a spotlight on transparency, accountability, and ethics. I've prioritized worker safety and public safety. I've stood up to major interests, and I stand committed to access to justice, starting a legal aid clinic 7 years ago, providing free legal services in Lake and Cook counties. I also teach at Northwestern University. I'm running for Supreme Court to continue supporting access to justice for all, recognizing the broad range of needs and bringing an independent and unique perspective to the bench, upholding the rule of law, and making sure that all Illinoisans have the fair and balanced adjudication of the major issues facing our state. I look forward to talking with you more this evening. And again, my name is Nancy Rotering, and I'm running for Supreme Court Justice. Thank you.
Thank you. Our first question will begin with candidate Rochford. And so the question is thus: what are your thoughts on how to reduce the lengthy delays in court proceedings that often stretch cases into costly multi-year affairs?
So there's really, just like with most things in the law, it's finding balance. As was mentioned earlier, justice delayed is in fact justice denied, but there's also a right to due process. And there has to be a proper balance between meeting all of those needs and requirements that are established by the law. There are time standards that have been established for various kinds of cases, and we need to be attendant to those on a regular basis. We have to be watching ourselves, and also in supervisory positions as judges, we need to be making sure that all of the judges are following those time standards. But there are always exceptions to cases, special circumstances that require cases to take longer for one reason or another. And that's where judicial discretion steps in, and a judge has to make those assessments, but always with an eye to making sure that everybody is having an opportunity to have their case heard in a timely basis, while also allowing them to have all of their issues fully considered by the court.
Thank you. Candidate Rotering, you have 90 seconds for the same question.
I think it's important that we maintain the balance. Obviously, you want to make sure that people have the fair opportunity that they've been accorded by the law, but also recognize the very real impact on the human lives that are in process throughout whatever the proceeding is, whether it's under civil or criminal proceedings. I think it's important also to focus as a court on encouraging and promoting the use of court-based alternatives to litigation, to do whatever we can to diminish the volume of cases that are filling the court system, and to fully recognize and understand the impact that these procedures are having. To the earlier point, there are rules established, there are expectations. We need to make sure that those rules are applied, and that all the parties recognize that there is an expectation that things will be resolved as expeditiously but completely as possible.
Candidate Cruz, same question.
Thank you. So yes, this is something that there's always been timeframes for how different cases get resolved. I've been in, I presided over both civil and criminal cases. And some just require more time because there is exchange of information that does take time to accomplish. But beyond trying to move cases, which is what we judges do, we have to be able to recognize when cases are being delayed intentionally, which is something that comes from being experienced on the bench. But beyond that even, we have the ability to create our own administrative rules to streamline processes as well. And I'll give you an example of that. As Justice Burke mentioned to us, that this pandemic actually made us modernize a little bit. So an example, I was the presiding judge of our family division courts, and we have a prove-up process, which means even though everything's in agreement pre-pandemic, it would still take 30 to 45 days before you could get in front of a judge, actually have the agreement approved so that your case could be completely finished. During the pandemic, I, as the presiding judge of the division, was able to streamline that process by creating an affidavit that the parties could fill out in front of a notary, sworn to, that they could just present with the document. So we went from a 30 to 45 day process to basically a 24-hour process where individuals could have an agreement, have it seen, presented before a judge, and be finalized, taking away all the worry, concern that it could be undone, that someone would change their minds, because we have the ability to make changes internally that can streamline the process as well. So we don't have to wait for others to do it for us. We have the ability to do it ourselves at the local administrative level, which is what I did.
Thank you. Candidate Radwin, we'll begin this question round with you. And the question is this: what changes in the law, such as the Criminal Justice Reform Bill passed last year, do you expect to have the greatest impact on court procedures and decisions?
I believe you're referring to the SAFE-T Act. And it's important to note that as a mayor, I've spent more than 11 years working with our police to prioritize public safety in our community. We've created shared principles of community policing that were created in partnership with the NAACP, and those have now been adopted by over 300 cities in the state of Illinois. What will change will be the volume of people coming through the court system with no cash bail. We're recognizing that for far too many people, they've been imprisoned because of being poor, nothing more. And I think the impact of having body-worn cameras, again, a focus on addressing the very real mental health and addiction issues that get so many people caught up in our criminal justice system. We will be seeing, hopefully, a more compassionate and a more appropriate approach to adjudicating these criminal cases. We know that in the state of Illinois, we need to provide resources, more resources for pretrial services and for public defenders. I hope that that will be a priority in an effort to ensure that everybody has fair representation, adequate representation under the law.
Thank you. Candidate Cruz, same question.
Yes, thank you. So everyone brings up the cashless bail portion. Judge Shaines mentioned earlier the two components. There is a pretrial release process that we in Kane County were a pilot program for that process. Now it's been adopted by the state, but early on it's been evident that paying certain amounts of money does not necessarily increase an individual's returning back to court or not committing another offense. So we've been doing that as a pilot program in Kane County for the last several years. And now we're a pilot program for the Safety Act as well. And as Judge Shaines mentioned as well, this is the law. So we're going to follow this law. A lot of notice requirements that we have to make sure that all the parties involved are adhering to, whether it's the arresting authority, the state's attorney. There's all these different timelines under which things have to be done that are going to be unusual for all of the stakeholders throughout the process. And our job is to make sure we hold them accountable to the law as written to make sure that they follow through. But I'm pleased that we're going to be a pilot program because there's going to be a lot of troubleshooting that takes place. I'm on that panel as well that's going to be studying the different impact to make sure that all of our stakeholders are aware of the different challenges they'll have as well. I unfortunately missed our first meeting tonight for this forum, but we started off with 100 pages of documents that we're going through and analyzing all the statutes to make sure that we have a framework in place that hopefully others can use when they start applying this as effective January 1st.
Thank you. Candidate Rushford, your response.
Thank you. So the greatest impacts will remain to be seen over the course of time. And I think that we can agree that the new laws were intended to address inequities And that there will be time as we go forward where, and that's exactly what the work of the courts will be, is interpreting the law and applying it to the specific facts. And that is going to be something that is going to evolve over the course of time. New laws are not always perfect, and sometimes they are need to be tested in the courts. And that will be the precise responsibility of the judges who are sitting hearing those cases. And the law is not static. It will, again, evolve as we go forward, as we learn, and as we make every effort to improve and create a system that is impartial and has integrity and that treats every person who comes into the courtroom with fairness.
Thank you. Candidate Cruz, this round will begin with you. And the question is, what are the effects of undisclosed and outside contributions on judicial elections? And what impact will the new judicial campaign finance rules, HB 716, have?
Yeah, that's interesting that you start with me, because I believe this probably had the biggest impact on me. As I mentioned, I grew up in the military. So, born in the country of Panama, lived 5 years in Kansas, 3 years here at Fort Sheridan in Illinois, then another 3 years in Virginia, and then another 3 years in Panama. So I don't have the long-term, lifelong connections to individuals that can contribute. Most of my friends, family, went to college in South Carolina. The people who would be supportive of me no longer can financially back me. It's the law. Maybe it's something that should be revisited. I think there's a certain reason it was done at this time based on the elections that are currently pending. But truly, we should not be having partisan, privately funded elections for the courts in Illinois. I had a conversation with the North Carolina judge who indicated last year, who talked about North Carolina previously having publicly funded nonpartisan elections. And it worked wonderfully until one particular party took control of the legislature and decided to change it to partisan. And exactly what they thought happened. Their entire party swept all the races until they lost control of the legislature, and the other party swept all the races. We really should be looking at the option of having nonpartisan, publicly funded elections for our judiciary, so we can take out some of the conversation that we've just heard in the prior candidates about some of the issues that are out there.
Candidate Rochford.
So the canons of ethics by which we are bound as judges and also as judicial candidates prohibits us from being involved in a fundraising component of campaigning. And we can't solicit funds, we can't be involved in collecting the funds, and we can't be involved in really the management or distribution of the funds. And that's with good reason, because judges are held to the highest standard when it comes to integrity and when it comes to impartiality. And we cannot be in any way bound to or influenced by anyone who were to be making contributions to our campaigns. So I'm not a politician. Wouldn't be running for office under any circumstances if it wasn't a judicial office, because this has been my life's work. So the whole campaign finance piece is very foreign to me, and I'm very glad to be separated from it. Because it will not and has not ever had any influence on the way that I operate in my courtroom.
Candidate Ruttering.
This has been a favorite topic of mine, and I think it's important to note that there's a very real issue in terms of the need for campaign finance reform, obviously across the board, but most particularly in the case of judicial races. To have so many dollars flowing into these races from the very attorneys who are appearing before these judges is a complete conflict of interest. There definitely needs to be campaign finance reform and publicly funded judicial races. The partisanship needs to be taken out of these conversations. It is absolutely contradictory to say we expect fair and impartial judges, but you still have to appeal to the voters to be able to get onto the bench. And there's one other piece that I think still needs to be addressed, and that is this insane Illinois rule that if one person breaks the caps on donations, The caps are lifted for all, and one single individual can provide millions of dollars towards these campaigns. So it's a beginning. I guess I appreciate the intention behind it, but I think there is some very real reform that needs to come, and this is simply the beginning of what needs to be a much larger conversation.
Thank you. Next question will begin with candidate Rushford. The state Supreme Court has given circuit judges the latitude to experiment with allowing news operations to select pool photographers to unobtrusively photograph court proceedings. In your opinion, how will this allowance affect the judicial process?
So a judge in a courtroom is responsible for keeping the courtroom in a professional way and making sure that everyone has an opportunity to be heard and that no one is in any way disadvantaged or any compromised, or a person is in no way disadvantaged or exposed in a way that would be inappropriate. And so it is the judge's responsibility to use his or her discretion in the courtroom to make those determinations when those cameras would be appropriate. And even if the decision is made that the cameras are appropriate in the courtroom, under what circumstances and how the entire administration takes place in the courtroom. That's a critically important responsibility of the judge. And as is typical responsibility of a judge is that the court has to consider the totality of the circumstances, all of the parties involved, and the case. Also keeping in mind that transparency is critically important to the public. And so just like with all the other jobs that a judge has, it's finding that balance to do the appropriate thing and make sure that all of the needs of the parties involved are appropriately met.
Thank you. Candidate Rodney?
I think we can all agree that sunshine is the best disinfectant. And by the same token, we still need to balance and recognize the need to account for very real sensitivities and protect certain witnesses and certain victims from publicity and from exposure to the public. But when I became mayor, I brought all kinds of cameras into my commissions. I think it's important for people to know who is saying what is being discussed. We had earlier candidates discussing that it might be boring. That's for the public to decide, not for the judges to decide. And I think most importantly, a free and open press supports liberty. It supports truthfulness. Every decision that I've ever made has been with the press in my room. And I feel that it is an important part of making sure that people recognize that they are here to serve the public. And the public deserves to know what they're discussing, of course, balancing the necessary sensitivities, as I mentioned at the outset.
And Candidate Cruz.
Yeah, so the extended media coverage is nothing new. It's been around for a good while, and there's not a whole lot to add other than it spells out the balancing test that a judge will do with the overall concern being the efficacy of making sure that a fair trial is offered to all the parties involved. When you say cameras in the courtroom, we do have to protect the identities of the jurors. The jurors need to be able to process as well. So we can't take pictures of the jurors. I'm getting something from.
I think you. Are we all getting feedback? Candidate Cruz, okay. Let's try again.
All right, so just going to indicate that there are certain things that you just cannot allow, as was mentioned in this balancing test. You cannot, let people take pictures of jurors while they're serving because that needs to be protected. Certain witnesses as well, sensitive information, all for transparency. People should know how their judiciary works and be able to participate. The unfortunate nature is that the ones seeking extended media coverage, they are the high-profile cases, but it's more for their benefit, not necessarily for the parties involved. Because they're looking at entertainment, which isn't always entertaining either. But our job is to make sure that we protect the efficacy and the fairness of the trial.
Thank you. And this will be our last question for this evening. And I just want to remind us all of the agreement that we made that we will offer your opinions and not address the other candidates that have spoken before you. So the last question is, what is your judicial philosophy on balancing the scales of justice, weighing fairness, and the strict interpretation of the law? And we'll begin with candidate Rottering.
Thank you. It's vitally important to recognize that as members of the bench, it is upon us to carefully look at and understand the issues, the facts of the situation, and then obviously to fairly and impartially apply the strict rule of law, recognizing the very real human beings who are standing before us and recognizing the very real human beings whom these folks may have impacted. So my philosophy is one of discretion. I have spent the last 12 years adjudicating complex decisions that could impact thousands of people, all with an eye towards maintaining fairness and balance, but recognizing the need for discretion and the very real impact that my decisions will be having on the human beings standing before me.
Thank you. Candidate Cruz.
Yeah, so speaking specifically of the courtroom context, having been a trial attorney for 17 years and having been able to see examples, good and bad, of when the process seems to be working for my clients, and now in my 10th year as a judge, being able to apply that knowledge as a litigator to those experiences. You know, individuals want to know that they've been afforded all the rights that the process allows. Even when they lose, they still want to know that the law was applied and how it may have or may not have applied in their favor. But we as judges have to be introspective. We're not perfect. We have to work on ourselves constantly. We have to work, and our judicial education helps us work on our own biases and understand that we have our faults as well, and that we continue to strive to be better. I can tell you on my bench, I have 2 Post-it notes, and one of them says listen, and one of them says smile. Because I think if I smile, I make the courtroom welcoming and make people relax and understand that I'm there to serve them. And listening is the most important part of my job as well, which means I need to make sure that I afford everybody the opportunity to participate. And then again, even when I rule, and I have ruled, to let them understand that even though the process did not perhaps work in their favor, how I applied it, so that they understand the logic behind it and they feel like they were heard.
Thank you. Candidate Rashford.
My judicial philosophy, is very simple. It's that courts are here to serve the community. The way that we can best do that, of course, is by being fair to the greatest extent possible, but it also requires us to be innovative, to think the courts in creative ways, to be self-examining, to know that there is always room for improvement. We have to be diverse, and we have to be responsive to changing needs. Justice Burke made specific mention of the change that we certainly didn't know that we wanted. We never asked for it, but it was probably the best thing that ever happened to us in terms of pushing us to a new level of service in the courts. When the pandemic hit and we had to translate what we had always done very traditionally in a courtroom to Zoom. And we have learned in that process that we can better serve the community in so many ways. I sit in probate court. I have an opportunity on a regular basis to communicate with senior citizens who are at their kitchen table instead of having to navigate the indignities of the security and being in a courtroom that is unfamiliar and can be very overwhelming and challenging. So learning from these experiences going forward, and then again, finding balance to make things, because there are some things that absolutely need to take place in a courtroom. So by being innovative and being open-minded, we can be the very best judiciary possible to serve our communities.
Thank you so much. And now we'll begin closing statements, and you have 1 minute for your closing statement. Candidate Cruz, we'll begin with you.
Thank you. So the time of thinking outside the box, I'd like to tell people, is over. This pandemic has actually put us in a position to reinvent the box. And since the pandemic hit, I've done exactly that in King County, and I believe I can take my administrative skills as a circuit court judge, a presiding judge over 5 other judges, to that Supreme Court level. I was the one that brought initially Zoom to our courthouse in the family division. When I was told that we would have to shut down for 2 weeks, I couldn't let that happen because the users of the system would not benefit from it. And we were up and running within a week. I also, during that time frame, helped spearhead an initiative to improve our interpreting services as well. And as a result, we saved our taxpayers $270,000 in 2021. I also am eliminating the need for defendants to appear in court, in my courtroom, if their attorney is going to be there as well. So individuals do not have to take off time from work, arrange daycare and other things. They can just let their attorneys appear on their behalf, and they can continue, so we don't and continue to improve or add upon the negative consequences of having to appear in court. Those are the kinds of innovations that I think I can bring to the Supreme Court. Again, please visit judgecruzforjustice.com.
Thank you so much.
Thank you.
Candidate Rochford, your closing statement, 1 minute.
So I just, with heartfelt thanks to each and every one of you for giving me this opportunity, for taking the time to learn more about the candidates and the work of the courts. I invite you to visit my website, Judge Rochford for Supreme Court, for 3 reasons. One, I hope you'll read an article that is in the news section of my website that was written by an internationally renowned judicial ethics scholar and former colleague of mine, Ray McCoskey, called Judicial Campaigns Different by Design. I think you'll find it interesting and enlightening, and it really helps to understand the difference between judicial campaigns and other types of campaigns. I also hope you'll visit my website because you can learn much more about me and my candidacy. And thirdly, because I hope that you will join me on the journey right here from tonight all the way to the Illinois Supreme Court, and then back to serve every community from the 2nd District to the Supreme Court, and then to every community in the whole state of Illinois. Thank you so much for the opportunity this evening.
Thank you. And Candidate Roddery, your closing statement.
Thank you again to the League of Women Voters. I think we can agree that a diverse bench best serves our mission of ensuring access to liberty and justice for all. The issues I face, the skills that I use as mayor, holding hearings, following rules of procedure, ensuring due process, gathering facts, identifying issues fairly and impartially, adjudicating complex and difficult decisions that can impact thousands of people, all translate to this role in the Supreme Court. And so many of the matters that come before the court would benefit from the perspective of someone who has had over 11 years of experience working with the police, who understands workers' compensation and public safety pension rulings, initiated and succeeded on constitutional issues, stood up to and withstood pressure from major interests, who successfully conducted an internal investigation protecting whistleblowers, and who's entering her 12th year as a fair and impartial leader, applying the law in a nonpartisan manner. I have a record of strong ethics, transparency, and independence. And I just thank you again for tonight's conversation. Again, my name's Nancy Rodering. I ask for your vote on June 28th. Please go to nancyroderingforjustice.com.
On behalf of everyone watching and myself, I want to thank you all for coming tonight and taking time out and spending some time with us to know who you are. And now you can turn your cameras off and enjoy the rest of your evening.
Thank you.
Thank you. This completes the forums for the Republican and Democrat candidates for the Illinois Supreme Court. We will take a momentary break before we begin the forum for the Democratic Appellate Court candidates. There will not be a Republican Appellate Court candidate forum as they are running unopposed. We'll be back shortly. Thank you. It is an honor for me now to introduce the Democratic candidates for Appellate Court. All Democratic candidates were invited to participate. The candidates have agreed to ground rules established by the League of Women Voters regarding the conduct and timeframe for the forum. So now I'd like to welcome candidate Michael Cortina, candidate Chris Kennedy, and candidate Aaron Cartwright Weinstein. Candidates, you will begin in alphabetical order with your 2-minute opening statement. And then we'll alternate the order in which you will answer questions submitted by the public and vetted for appropriateness by the experienced League of Women Voter members. Your answers to questions will be limited to 1.5 minutes. You will see time prompts on the screen and the question portion of the format. And after the question portion of the forum, you will be able to give a 1-minute closing statement. So let's begin with opening statements. Candidate Cortina, you have 2 minutes.
Thanks very much. And thank you to the League for inviting me and for having this forum. This is a great opportunity. My name is Mike Cortina. I've been a lawyer for about 25 years or so. I've been rated by Martindale-Hubbell Peer Review Rating Services, which is the oldest attorney peer review rating service in the country. They've been around for about 130 years or so. They're considered the gold standard of attorney peer reviews. And they have rated me as preeminent, meaning I have the highest level of legal ability and ethical standards. This is an elite group. Only about 10% of attorneys in the entire nation get this rating, and I'm one of them. I'm also the son of a Cuban immigrant. My father came to the United States and eventually went back to law school again and became a law professor and helped to teach those in marginalized communities. And like my father, I've also taught the law, not only to students, but also to lawyers. I am constantly called and asked to come to speak to other lawyers in order to teach lawyers the law. I'm also extremely well published. I have over 40 legal articles in various publications, and that matters because for the appellate court, it's not like a trial court where judges listen to objections or have to determine credibility of witnesses. No, they're academics. They study, they read, they learn the law, and they write about the law. And that's what I've been doing for 25 years. And finally, I'd like to say that I am proudly endorsed by my fellow veterans at Illinois Veterans for Change, also by personal PAC, also certain individuals like Lake County Treasurer Holly Kim, State Rep Bob Morgan, Rita Mayfield, and many others. So again, thank you, and I look forward to your questions.
Thank you. Candidate Kennedy, your opening statement.
All right, thank you everybody for attending and listening, and thanks to the League. I'm Chris Kennedy. I'm a trial court judge here in Lake County. I'm assigned to the criminal division where I preside over thousands of cases, including traffic, DUI, misdemeanor, domestic violence, bond court matters. I'm the only judge in this race. I'm the only candidate to be rated highly recommended by the Illinois State Bar Association after their extensive review process. I am endorsed by Personal PAC as well, but I'm the only candidate endorsed by the Independent Voters of Illinois, Independent Precinct Organization, and by labor, the AFL-CIO, Illinois Federation of Teachers, the Association of Firefighters of Illinois, Northeastern Federation of Labor, Building Trades Councils, et cetera, many more, and many elected officials. But that support is because I've demonstrated leadership in various roles of public service over a couple of decades in the law. I have a real world background growing up in a blue collar family. I went to law school on a scholarship. I made the law review, won the writing award, was an executive editor. I interned with the U.S. Attorney's Office and a federal judge, and then became a felony prosecutor in Lake County. I took my extensive criminal trial experience eventually to a firm in Chicago. I tried multi-million-dollar civil jury trials, and I began handling appeals. I appeared before the Federal Court of Appeals, first and second, which is the court that I hope to serve on soon. In addition, my contributions to the community have included 12 years on the school board, but most significantly, when my daughter had developmental delays, I became an advocate for others like her and changed the law in many ways to help thousands, tens of thousands of families become more independent and capable of serving their children and their needs. So, okay.
Thank you. Candidate Cartwright Weinstein, your opening statement.
Thank you. My name is Erin Cartwright Weinstein, and I'm your candidate for the 2nd District Appellate Judge. Currently, I am the Lake County Circuit Court Clerk. I won my first election in 2016 against a Republican incumbent. and I was the second highest vote getter in Lake County. And this was before Lake County was blue. I won my second election in 2020, where I was the third highest vote getter, but President Biden beat me, which I'm perfectly fine with. I'm the only Democrat on this ballot for this position who has won a race. I practiced law for almost 17 years prior to being elected as circuit clerk in 2016. I practiced in criminal prosecution, defense, orders of protection, guardianships for minors and adults in probate, adoptions, and juvenile abuse and neglect matters. I was an assistant state's attorney for 4 years. I opened my own law practice, and I worked as an associate attorney in a family law firm. After becoming the circuit court clerk, I started by settling the first union contract that had been fought by my predecessor. My staff was making $12.78 an hour. Today, they're making $19.90 an hour. My office is 90% women, and we were the second lowest paid department in a county despite being the fourth largest. This has taken perseverance and patience. I have 138 employees, and I've had to learn to be a compassionate leader and competent in employment law. My office is part of the judicial branch of government. We work with judges behind the scenes to improve efficiencies, make changes as required by the law, help the public gain access to the court system, and keep all of the records for every court call. Access to justice is imperative. I have found that the system in our court system it is very procedural. However, for the people who come into our department, to our offices, it is not. I've written legislative laws, and I have implemented the laws in my office. I'm an active member, and I hope you will support me going forward. Thank you.
Thank you. Now for the first question. We'll begin with candidate Kennedy. The question is this: what are your thoughts on how to reduce the lengthy delay in court proceedings that often stretch cases into costly multi-year affairs?
In my work on the bench, I am very mindful of the time it takes to bring a case to resolution. Justice delayed is denied to many, but it's also a negative reflection on the judicial system. And we live in a time in which the judiciary is held in the lowest esteem it's ever been. Most of that is due to politicization that is perceived about the courts, but also the courts are not always perceived to be efficient or to be fair to everyone. And that is the role that I serve as a judge. But in my 25 years of practice before that, I had many instances in which I and my opponent in a case were afraid to call the judge and ask, where is the ruling that we had asked for months and months ago? And what are the reasons why these things might be put off? Well, one, could be overwork. Two, could be inefficiency. Or three, it could be just a lack of knowledge, perhaps fear to dig into the issue, being afraid to make a decision. I'm not afraid to do that. And I'm not afraid to stand up and make sure that cases get worked quickly and this happens at the appellate court as well. In many jurisdictions, it takes so long that it may not even be worth pursuing for one side or the other, or the decision doesn't come soon enough. People's lives are being lived now, and people deserve prompt justice. And so that is something that I bring to the trial court, and I will bring to the appellate court.
Thank you. Candidate Weinstein, the same question.
Thank you. So the balance is incredibly important, and there are two strong words for this. One of them is case management, and one of them is time management. We have to ensure that we are moving through these court calls in a fair manner to the litigants. They have to know that they're being heard. They have to be able to have their due process rights met. But we also have to assure that we can finalize these cases, because lengthy cases disrupt people's lives. And we need to really focus on ensuring that people can move on after these situations and they don't linger on for years and years. In 2020, I was asked to present at the judicial conference, the Illinois Judicial Conference, and we specifically spoke to the judiciary and circuit clerks on high volume courtrooms and the impact that that has on litigants. And that was a huge problem that had occurred back when we had the foreclosure calls in 2008 and 2009, and our courtrooms were packed and we couldn't get through the cases. And being able to speak on that and the impact it has really brings to light the fact that we have to really balance all of the needs of our litigants, but also ensure that we move these cases through the process in a compassionate but timely manner. Thank you.
Thank you. Candidate Cortina, same question. Great,
thank you. I look at this from both the civil law and the criminal law aspect. On the civil side of things, I've been a small claims mediator for any number of years, where I volunteer my time to help mediate small claims cases with pro se litigants that don't have an attorney. That is, and the point of what that is, when it occurs and mediation is successful, which usually it is, the case is done on the very first day that there's a court appearance. And so that's one way of reducing the backlog of cases and getting it resolved and over with quickly. Another way of doing it is having volunteer lawyers. I'm part of the McHenry County Bar Association program where we volunteer to help people with legal issues. We don't charge them anything. And we give them suggestions on how they can proceed to try and get things resolved quicker. On the criminal side of things, it's a little bit different. We have not only Zoom court, which I would recommend we keep as we've got it now, because it does help speed up the process, but we also have specialty courts, different things like drug treatment court, or something very dear and near to me, veterans court. Those specialty courts not only help people who have issues that aren't necessarily criminal issues with drug or mental health issues, but also help remove those people from the criminal court system itself. So that's another way. Thank you.
Thank you. Candidate Cartwright-Weinstein, we're going to begin with you. What are the effects of, what changes in the law, such as the Criminal Justice Reform Bill passed last year, do you expect to have the greatest impact on court procedures and decisions?
So under the Safety Act, they made so many significant changes to requirements for the police departments, requirements with the no cash bail. And I think all of these requirements are going to evolve over time. And so as the courts are addressing these new issues and seeing the impact of this legislation, we are going to find that there are going to be things that are going to have to be changed by the legislature is probably going to change over time, or they're going to be, certain issues that the court's going to have to make some interpretations on. But it's very difficult to tell exactly what's going to be the most impact. I do believe that we are going to have to ensure that the courts have the resources that they need in order to be able to comply with this law. We are going to probably see an increase in the number of public defenders. We are going to see an increase in the need for pretrial bond services and the resources that pretrial bond services have in order to assist the litigants in these criminal cases. It's also, I do believe, going to bring some more transparency along with the body cameras, that, the people will, the police will have an ability to be able to protect themselves, and the litigants will be able to have proof as to what had occurred to them. So I believe that there's some good aspects to it as well, but we are going to have to see over time how these changes impact our society.
Candidate Cortina.
Could you repeat the question for me, please?
Sure. What changes in the law, such as the Criminal Justice Reform Bill passed last year, do you expect to have the greatest impact on court procedures and decisions?
Oh, thank you. It's kind of interesting because, as a judge, the laws are constantly changing. Judges are always having to learn new laws. The law might be one way one day, and then the legislature changes something and it's to do a law the next day. And as was mentioned prior, judges don't have the luxury of liking or disliking laws. They have to follow and implement the law. So certain things like, say, the Safety Act, the no cash bail, it will have something of a profound impact on our criminal justice system. But what that impact will actually be, we're not really sure. We can sit there and speculate all we want and try and guess, but we really don't know. As a judicial candidate, my job is to know and understand what the law is so that I'll be able to implement it day one, hit the ground running and go. So certain things like that, or other laws, like say Judge Shaines mentioned the prejudgment interest changes. I've been following that very closely. A lot of my clients, a lot of my cases are in civil matters, and we deal with the interest, prejudgment, post-judgment, consumer, commercial, what have you. We have to know and understand these things. So the fact that these laws are constantly changing right now, we don't know exactly what the impact will be, but our job is simply to know what the law is. Thank you.
Thank you. Candidate Kennedy, same question.
Thank you. I can think of three. One, obviously the no cash bail will be a significant change. However, we've already begun implementing changes geared toward that. We have a new assessment tool in bond court. So when I preside over a bond hearing, I have a lot of additional information than I used to have. The assessment is done based on risk factors that are different than they traditionally have, which is one tendency that used to keep people incarcerated pre-trial unnecessarily, and which I think was one of the motivations behind the law. But we've already started on that path, and the federal government has already had for many years a cashless system. And so the courts are going to have to adjust to it, and I think there are various incentives in each direction on that. I mean, there will be positive and negative consequences from this. It'll depend on how the trial courts are held to the highest standard. And so that's a big one. The other one is prejudgment interest, which I had a lot of clients that were on the other side of the people that were holding on to money unfairly. And my clients were entitled to funds that had been delayed for a long time by the other side so that they could keep the interest that they gained off the money. And so that may speed things up on the civil side. And then one other piece, which I think we'll get into in a little while, is the task force that was recently set up to look into public funding of judicial races. I think that in the long term could have a major impact.
Thank you. Candidate Cortina, we'll begin with you for this question. What are the effects of undisclosed and outside contributions on judicial elections? And what impact will the new judicial campaign finance rules, HB 716, have?
Well, much like Judge Cruz indicated earlier, I was not born and raised in the state of Illinois. So a lot of my close family and friends, because of the changes in the law, are unable to donate to my campaign. My brother was literally planning on doing it, and all of a sudden the law took effect, and I had to call him and say, sorry, you can't. A former partner of mine who just retired to move to Florida donated to my campaign, and I had to turn around and send the money back to him. I appreciated the effort and the thought, but it couldn't happen. My family, we're all academics. We are spread out across the country. And so my family, people who normally do donate to campaigns so that we don't go out and create any kind of perceived conflicts of interest by taking money from lawyers who may be appearing before us. Family members are usually the ones and close friends who donate. We're unable to do so. So it is a large impact. I understand the reasoning behind the law. However, sometimes there are unintended consequences to the law, and it's going to take some time in order to work through these to see what works, what doesn't work, and eventually I'm sure the legislature will be able to come to something that strikes the proper balance.
Candidate Kennedy?
The dark money has had a pernicious influence on not only the political branches, but on the judicial as well. More and more money gets spent by outside groups that doesn't disclose where the money came from, and therefore doesn't disclose its motives. And I think that's been perceived as being extremely unfair and having a negative impact on the perception of the judiciary as independent from the political branches. And I think that is absolutely critical to the work that we as judges do, that we maintain the integrity of the judicial branch that gets to decide on the constitutionality, for example, or the scope and extent of laws that are passed by the other two. We need to be independent. We need to have the integrity that separates us from the other two branches. Now, nobody is going to be donating from my family, even though all of my family is out of state as well. That wasn't going to happen. But in terms of whether we as judges are going to maintain our independence and integrity, I think it's completely dependent on whether we can separate ourselves from the moneyed interests that tend to take hold of these races. And the money side tends to win because these are advertising just like every other campaign, and advertising depends on how much money you have.
Thank you. Candidate Cartwright Weinstein.
Thank you. So I think this has definitely been a popular topic for a very, very long time. I mean, I think when you take a look at the judiciary, you have to stay impartial, and receiving money from big business, from from attorneys that practice in front of you, it just gives a really bad, it gives a bad perspective to those who trust you and want to believe in what you're doing. And I think that, we have to stand behind the law. This is the law. We don't get to decide if we like it or we don't like it. This is just simply how it works. And so I think that at this point, we'll see how everything works itself out, but thank you.
Thank you. Candidate Kennedy, next question will begin with you. So the state Supreme Court has given circuit judges the latitude to experiment with allowing news operations to select pool photographers to unobtrusively photograph court proceedings. In your opinion, how will this allowance affect the judicial process?
So for one thing, I'm on camera in my courtroom every day. Zoom has brought that about by necessity. And I find that that has led to not only greater attendance, but a greater understanding of court processes. And some of the worry that came from those who were against any cameras in any courtroom ever traditionally had to do with showboating and some of the excesses of some of the participants. But in most cases, that is not what occurs. In most cases, and if lawyers are going to showboat, they're going to showboat anyway, whether they have an audience of 1 or 1 million. And so the impact is really going to be on, I think, the public's understanding. And if anyone out there has seen The Staircase, and if they haven't, they should. It's a documentary of a very lengthy court case in North Carolina. And the footage that came from that eventually was reviewed by the judge himself. And I won't give away any spoilers, but the judge's own comments put things in perspective, because really you don't know what your how you come off or how your decisions seem until you have the opportunity to review them. And if you can review your own conduct on video, for example, that can certainly assist in the quality of your decision making and your demeanor as a judge. And so I am not against the expansion.
Candidate Cartwright Weinstein, your thoughts?
Thank you. So I think as a judge, you have to create a decorum. You have to have a respectful courtroom that is free of disruption. And some cases can be incredibly sensitive. And even though the courts have expanded to Zoom, there are times that, that the Zoom is kept private, and those cases are heard without being exposed to the entire world. The Zoom cases are not recorded. So as much as I appreciate transparency, I believe in transparency, and I think that, reporters are allowed in the courtroom and they are able to hear and see what happens. I think you have to be very, very careful and very, very sensitive to litigants that are having very, very difficult times in a courtroom. No one wants to be there. They're there because they have to be there. They were, for whatever reason, whether they're in trouble, in a criminal case, or they are fighting in a difficult civil case, we have to ensure that their privacy, you know, to the best extent that we can, is maintained. I don't think that showboat, you know, as Judge Kennedy just said, showboating is something that we can, you know, that we should allow in the courtroom. But then on the other hand, transparency is very important, and the public should be aware of what their public servants are doing. So it is, I think it goes case by case.
Thank you. Candidate Cortina.
Thank you. When I was an assistant state's attorney, the dash cameras for police officers were first being implemented where I was. And I remember talking to one officer, a deputy, and asking him what he thought about it. And I was fully expecting the answer of, this is awful, somebody's gonna be looking over my shoulder the whole time, it's terrible. And I was surprised that his response was actually just the opposite. His response was, it'll make me a better officer. And that made me understand even more so how I think he was right. And the courtroom, it's the people's courtroom. It is a public courtroom, except for certain circumstances, juvenile court, things like that. But the public is able to go there and be there, and should be allowed to be there to participate, whether they are there physically in person or sitting behind a desk at a computer like we all are right now. Cameras in the courtroom, I've seen litigants, attorneys, judges do and say things that they would not have done or said had cameras been rolling, so that everybody, the entire world, can see what it is. So I'm in favor of it. I believe that sunshine laws, things like that, are very beneficial, and I would have no objection to expanding cameras. Thank you.
Thank you. Well, candidates, this is your final question. And the question is this, and we'll begin with candidate Cartwright-Weinstein. What is your judicial philosophy on balancing the scales of justice, weighing fairness, empathy, and strict interpretation of the law?
People in the courtroom are going through the most difficult times in their lives. They are trying to understand and navigate a courthouse. They're intimidated by the judge in front of them. And it is really, really important that the people are heard. And they need to be heard. They need to feel that they were heard. They need to have, you know, patience from a judge, and they need to feel that they've been able to participate in the case. We have people from all different cultures, all different walks of life that come into the courtrooms, and they have, you know, different perspectives on what they're going through. And so you have to be able to balance that, but then also keep a courtroom that has decorum, that maintains respect, and you have to continue to follow the law and be, you know, and be compassionate at the same time. So I know I can state that I do work on the electoral board, and we do the hearings for the petition objections in the county. And when those come through, you have to spend time with them afterwards and explain to them why you made the decision that you made, and so that they walk out understanding what happened and not just feel that they were just thrown out of the courtroom or you just did whatever it is what you were going to do, but that you were actually there and allowed them to participate in the scenario. And I think that you have to be able to still stand your ground, but then allow them to feel heard.
Thank you. Candidate Cortina.
Thank you. Actually, balancing the scales of justice is actually one of the reasons I decided to run for the appellate court in the first place. The second judicial district, the 5 counties that's comprised of, is almost 25% Hispanic. Yet there is not one single Hispanic justice on the appellate court. And as far as I can tell, there never has been. And that needs to change because with 25% of the population being Hispanic and no Hispanic justice there, 1/4 of the population is wondering, is justice something that is there for me, or is our system of justice just something that happens to me? And that needs to change. That's why my election would help balance the bench somewhat and help balance the scales of justice so that people can understand that the system of justice is there working for them and they are a part of it because part of them is also with it. Thank you.
Thank you. Thank you. Candidate Kennedy.
This afternoon, I had a defendant in front of me for arraignment on a misdemeanor who was not communicating very well to me. And I asked her what was going on. And she said that she was preparing for her son's funeral. And so I granted her an extension of time for a couple of months and apologized for what she was going through and offered her empathy. Now, you know, these are things in the real world that you see every day in a courtroom, and people are going through terrible crises sometimes with not only the case, but in other aspects of their lives. I'm really careful to make sure everybody in front of me is treated respectfully, fairly, transparently, that they're going to receive a full and fair hearing. Their rights are going to be protected, and any decisions made are going to be justified, explained, and I make sure that they understand. And if there's a judicial philosophy behind that, it is service, because that is ultimately what we are here for, is to serve the public and the interests of justice under a system of laws. And if we're not sensitive to the people behind us, in front of us, and know what is behind the cases, the context can be critical, and we as judges do a disservice if we don't keep that in mind.
Thank you all for your thoughtful answers. And now it's time for closing statements. And we'll begin with candidate Cortina, and you have 1 minute.
Thank you very much. I'd like to thank the League of Women Voters for again, putting on this forum. I think it's vitally important that everybody have the opportunity to be able to listen to and vet and learn about all candidates. Unfortunately, judicial candidates are usually the least known about. I mentioned at the beginning many of the endorsements that I have. I encourage everybody to please go to my campaign website, cortinaforjustice.com, number 4 or word 4, either way. I'd also mentioned earlier how the 2nd District is 25% Hispanic, and being Cuban, son of a Cuban immigrant, I would help to balance the bench. And finally, service to the community is one of the other reasons I'm running. And as a veteran, I not only talk about service, I actually believe in service, and I serve in the service. It's part of who I am. It's ingrained in my being. So thank you for your time, and good night, everyone.
Thank you. Candidate Kennedy, your 1 minute closing statement.
Thank you, everybody who has stayed up late to hear us. The judicial branch is perhaps the most important and least understood branch that we as citizens have a right to participate in the election of. And thank you for helping us get the message out. I'm running because I believe that I have unique qualifications. I have an extensive and diverse background in many areas. I have made law as an advocate. I've enforced it as a prosecutor. I've protected the rights of ordinary people, my clients who've been victims of crime, who've been victims of negligence and wrongful terminations, etc. And I've decided law as a judge. I believe that background, including the real life service that includes extraordinary efforts that really my wife allowed me to engage in over many years to help families like ours, help me to bring perspective to the appellate court bench. JudgeChrisKennedy.com. Sorry.
Thank you. And candidate Cartwright Weinstein, your closing statement.
Thank you. There's so much at stake right now with everything happening, and we really need to have a judge in the appellate court that we can believe in. I took my oath as an attorney and as a circuit clerk very, very seriously, and I was endorsed by the Daily Herald for continuing to keep my promises to the public. And what I can promise you is that I continue to take my job seriously, and I will bring to the appellate judgeship a passion, and I will uphold the Constitution, and I will continue my access to justice to bring fairness to everybody. I'm a member of the Coalition to Reduce Recidivism to help people when they're coming out of jail to have a better future. I work with Women United to help educate minor children, pre-kindergarten, and underserved communities. And those types of things, along with all of the things that I've done in my career, bring a very new perspective to the bench. And I believe that I'm a woman who can win. I have done it twice already, and I hope you have your support in June. Thank you.
And on behalf of everyone watching at home and myself, I want to thank you for spending your time with us tonight and answering our questions. And now you can turn your videos off. Thank you.
Thank you.
All right, thank you.
I want to thank everyone for watching. Our democracy thrives when all of us are engaged. Attending or watching a candidate forum is a great way for you to empower yourself to make an informed decision on election day. We hope that each and every one of you will vote and encourage your family, friends, and neighbors to do the same, so that all will express their preference on the direction and policy of the government by voting for the candidates of their choice on June 28th. Information on how and when to vote can be found on IllinoisVoterGuide.org, your local League of Women Voter website, or your local county commission website. And with that, good night.